What is an eviction? An eviction is a formal judicial procedure, a lawsuit, that takes place in a justice of the peace court and sometimes county courts. A landlord may try to remove a tenant for failing to comply with the lease agreement, such as failing to pay rent or violating other terms of the lease. Can I be evicted without an eviction lawsuit? No. Pursuant to Texas law, a landlord cannot subject you to eviction using self-help remedies or by any other process other than the judicial process required by law. What are the steps leading up to an eviction? First, the landlord must give a proper notice to vacate to the tenant. A notice to vacate is a demand for possession of the property for a breach of the terms of the lease. A notice to vacate must be in writing and delivered to the tenant. The notice to vacate must give at least 3 days to vacate unless the lease agreement sets a different time period. A notice to vacate may be delivered in the following ways: by personal delivery to the tenant or any person over the age of 16 residing at the unit, by certified register or regular mail, by attaching it to the inside of the front entry door, or by attaching it to the outside of the front entry door in a sealed envelope. The envelope must have the tenant's name, address, and in all capital letters, the words "important document." This method should be used only if there is no mailbox and the landlord cannot enter the unit because of a dangerous animal alarm system or keyless deadbolt that prevents the landlord from entering the premises, or if the landlord reasonably believes that the harm to any person would result from any personal delivery to the tenant or by affixing the notice inside the main door. The landlord must also deposit a copy of the notice to vacate in the mail, no later than 5 p.m. of the same day. Service. If a tenant does not move out by the deadline in the notice to vacate, the landlord may then file an eviction suit in the Justice of the Peace Court in the precinct where the property is located. The suit must be served to the tenant through a citation delivered by the constable's office. The citation will set a hearing date for the eviction trial. Trial. The eviction trial is held on the date provided on the citation. The tenant does not have to file a written answer. During the trial, evidence will be heard by the judge. The tenant may request a jury trial. In such case, the tenant must file a written demand with the Justice of the Peace Court and pay a jury fee at least 3 days prior to the trial date. What are my appeal rights? If the judgment is in favor of the landlord, the tenant has 5 days to appeal. If a tenant does not file an appeal within 5 days of the judgment, the landlord may seek a writ of possession to have the constable remove them from the premises. The constable will post a 24-hour notice on the front entry door of the unit prior to executing the writ. If the writ is executed, the constable will remove the tenant and their belongings from the unit. This is just a brief overview of frequently asked questions about evictions. Lone Star Legal Aid may be able to offer you free assistance with an eviction through our medical legal partnership. Ask your clinic staff for an MOP referral form to see if you qualify for Lone Star Legal Aid's free legal services.